Right. Well, they always have. I'm not gonna get into it too much.
Good morning. Please be seated. We're here today for oral argument in our case number CV120721 and CV120726. These proceedings are being audio and video recorded, and we would ask you to identify yourself and your client at the beginning of your argument. We've scheduled the argument to have 20 minutes on each side. We have discussed this, and if you would like to take 25 minutes, we'd like to give you 25 minutes per side. And appellant's counsel is responsible for watching the clock to reserve whatever time you might like to reserve for rebuttal. We have read the briefs and have conferenced this case and have discussed it extensively, but we look forward to your argument. With that, counsel, you may proceed.
May it please the court, and good morning. My name is Robert Burke, and along with Lori Vopel and Jennifer Anderson, we represent the appellants and the appellee on the cross appeal. I'd like to reserve 5 minutes for my rebuttal, and I'll try to watch the clock myself. This case involves complicated facts, most of which, frankly, arise from the convoluted $35 million quote-unquote Morris Agreement. CMLC characterizes that document as a Morris Agreement, and that's what I want to talk about this morning. The case also raises several important legal issues, including CMLC's attempt to extend Morris to title insurance. Because that issue has been extensively briefed by the parties, I do not intend, subject to your questions of course, to argue that issue this morning. Instead, I'm going to focus on an even more fundamental issue, which is the second argument we raised on appeal. And I should add that the question of the application of Morris to title insurance not only was briefed by the parties, but is also addressed at length in the amicus. Here's the fundamental question I'd like to talk about this morning. Is the agreement in question, the $35 million settlement agreement between CMLC and the insureds, a Morris Agreement? Because if this court concludes that it is not a Morris Agreement, and I submit that legally it cannot be a Morris Agreement because it is not between the necessary parties, namely the insureds and a third-party claimant. If it is not a Morris Agreement, then this court actually doesn't need to decide the issue of whether Morris applies to title insurance, or even whether the agreement that they struck is reasonable or non-collusive. The agreement is not a Morris Agreement, or frankly, even in the same area code as a Morris Agreement, because it's not between the insureds and a third-party claimant, but rather between the insureds and an entity the insureds created solely for the purpose of entering into this agreement.
But are you saying a claimant can never assign its claim to someone else?
Right, a third-party claimant can't assign its claim to a third party that then enters into the Morris. The narrow
Under what's your authority for that?
That's what the authority is Morris. Morris is the exception to the general rule. The general rule is that an insured cannot enter into a settlement agreement without the carrier's consent. Morris creates a narrow exception to that. It says you can enter into an agreement with a third-party plaintiff if you're being defended under a reservation. There's no authority for the proposition that you can enter into an agreement with anyone else. And one step further, there's absolutely no authority for the notion that you could create a new entity or have a friendly party reach an agreement with the plaintiff.
What if there's a third party plaintiff who just assigns a claim to their brother? They're just about to die and just want to assign the claim to their brother, and the brother pursues the claim. Why would that be problematic?
Well, again, it's outside the scope of Morris, and it's problematic because you have, that's not the situation here, of course. Because here...
But you're suggesting that there's no way that anyone other than the original claimant should be entitled to enter into some sort of agreement.
Someone who truly stands in the same shoes as the third-party plaintiff and has no differing interest than the third-party plaintiff, that's another matter. I guess in that case, there would be no collusion, no fraud, and no prejudice to the carrier. The problem, of course, is when the insured and the third-party assignee are the same party. That's what happened here. What is a Morris Agreement? What makes a Morris Agreement different than any other settlement agreement is that it's an agreement between the insured and a third-party plaintiff that involves the insured protecting itself. Typically involves deal points like a covenant not to execute and an assignment of coverage rights. But the analysis in this case doesn't need to get that detailed. In order to have a Morris agreement, you need first and foremost a ready, willing, and able third-party plaintiff. And the agreement, if one is negotiated, is between those parties. Here, even if the lien claimants qualify as third-party plaintiffs under Morris, and that's the issue of whether Morris applies to title insurance, that isn't who this agreement was between. The situation here is not uncommon. You have an insured being defended under a reservation of rights. The insured approaches the plaintiff and proposes a Morris. The plaintiff says, no, thank you. And that happens. Sometimes the plaintiff isn't willing to trade its liability claim against the insured for a coverage claim against the insured's carrier. So the plaintiff says, no, thank you. What can the insured do in that situation without breaching its insurance contract? Well, they have at least two options. One is settle directly with the plaintiff. Settle with the plaintiff, sue your carrier for breach of contract and bad faith. And the issue in that case would be who breached first. Did the carrier breach first by reserving its rights improperly? Alternatively, the insured can let the litigation run its course against the third-party claimants, hope to win that litigation, or hope to win the subsequent coverage litigation against its carrier.
What if there's a different sense of urgency as between the insured and the insurance company, that the insured just needs to get this resolved within 3 months? The insurance company's willing to litigate for several years. Is there, what would the remedy be for the insured in that scenario?
Well, the first option I just mentioned, settle the case. That's essentially what happened here. The insured essentially took $13.5 million and paid off the lien claimants. The problem is if they had done the agreement in that kind of simplified, streamlined form, their claim against Fidelity would be for $13.5 million. That's their option here. Settle and sue your carrier for breach of contract and bad faith.
What's the bad faith, though, on the part of the insurance company that is entitled to control the litigation under the terms of the contract?
The bad faith would only be, the breach of contract claim in that scenario would be the insured claim that the carrier breached its contract by reserving its rights improperly. They can file that lawsuit. I don't think there is any bad faith on the part of the carrier as long as the carrier acted appropriately. But on the breach of contract claim, their consequential damages would be, if they prevail, the $13.5 million they paid to the lien claimants. That's an option for them. That's the right option.
I'm not completely following. I
Okay,
apologize.
so
Let's just assume they've filed a claim for 13.5, or they go to Fidelity and say, we want to settle this for $13.5 million. We want to enter into, we're going to call it a Morris agreement, or we just have an agreement to do that. We want you to pay 13.5. And Fidelity just says, well, we don't want to settle right now. We want to litigate and get rid of all of them. So you're saying they have a claim for
the insured
bad
pays
faith?
I'm sorry, Your Honor. The insured pays the 13.5. That's what happened here. They sold
do
the bill.
do they have any claim then against Fidelity?
Absolutely.
But how is it bad faith if Fidelity can control the litigation?
Well, it's bad. Go ahead.
How do they have? Sorry to jump in. How do they have how would they still have a valid claim? They breached the contract.
No, because then in the subsequent breach of contract case filed by the insured against Fidelity, the breach of contract claim is that Fidelity breached the contract first, the insurance contract.
By doing what?
By taking an unreasonable position with regard to the reservation of rights, and by not allowing the insured, not paying the claim. That's a subsequent breach of contract case. That's not an unusual scenario. That's their option. And again, keep in mind, that's what they did here. They sold the building and paid the lien claimants $13.5 million. That's what happened. The lien claimants got paid off here. This wasn't a Morris agreement in the normal sense where the plaintiffs took nothing except an assignment of coverage rights. The claimants settled. They were completely paid off. So now they have a subsequent case. The only reason that they did a Morris, quote unquote Morris, is so that $13.5 million payoff could be manipulated into a $35 million judgment. And the only reason it was converted to a $35 million judgment is because both the the insureds and CMLC are essentially the same party. That's why they did this.
But are you saying the claimant can't take any money? Can you do a hybrid where you take some money and then assign part of the claim?
Absolutely. Absolutely. As long as they're on opposite sides of the transaction, but when they have the same ownership and the same financial interest, and they're both going to share in the bounty from the carrier, that you can't do. Absolutely. There are certainly cases where the plaintiff says to the third party, we're interested in a Morris, but we're not wild about your coverage case, so we need some sure money. Give us $100,000 cash and an assignment. That's fine. That's different than having the same party on both sides collectively pursuing the insurance company, which is what happened here. There is no authority for this proposition that a insured can create a friendly entity and buy out the plaintiff and then settle with itself.
Yeah, but let's just take apart the separate entity that was created. Let's just say they propose an agreement where they're going to pay the cash immediately to the mechanics lien claim holders, and they want Fidelity to pay without a reservation of rights. Well, that's I guess what happened.
Right.
But why would they? And I guess I'm kind of going back to why would the sky fall in if we say Morris applies in this situation? If we said Fidelity has the option of either paying the 13.5 and if they pay the 13.5 and still if they choose to reserve their rights, then they've let someone else negotiate what appears to be a good settlement, and they still have the opportunity under Morris to come in and challenge the reasonableness of the settlement. And if there doesn't seem to be any question that the 13.5 was a reasonable settlement at this point.
Of the lien claims, right. Which are the only covered claims.
Okay, but if that were the settlement, should Morris apply?
Well, and that's the debate over whether Morris should apply to title insurance. And if they were here, if what they were coming to this court with, or if they came to Judge Burke with, was the $13.5 million settlement with the lien claimants, that's a reasonable settlement. There would be no, and even though it would be collusive in that.
Should Morris apply then in that?
We've argued at length in the brief, Morris shouldn't apply to title insurance because it's outside the confines of Morris. But that's really not, we don't need to reach that. I'm happy to discuss that because this isn't a Morris agreement anyway. Here's what could have happened. They could have simply reached a settlement with the third-party claimants saying, we settle for, we're going to stipulate to a $13.5 million judgment, and the insurers are going to assign to CMLC their rights against Fidelity. That could have been the deal.
But then haven't they breached their contract with Fidelity that says they can't settle without Fidelity?
Well, that would be a classic Morris situation. If Morris applied to title insurance, that would be a classic Morris situation.
But even so, the contracts, the lender's policy here specifically states that the company shall not be liable if there's a settlement without Fidelity's express consent.
Right, and I'm not going to argue against that clause. It's in our favor. However, Morris says, in the narrow confines of Morris, an insured can settle without the carrier's consent without breaching the cooperation clause. That's the exception Morris creates. So
I understood, and technically speaking, that's not in the cooperation clause, and it's in a separate portion of the agreement. I don't know how what Morris intended, how far to go. What does it mean, a cooperation? What does the cooperation clause mean?
Well, it certainly means, and I think Arizona law is clear, that you can't settle the claim without the carrier's consent. Morris says there's an exception to that rule. If the carrier is defending under a reservation of rights, the insured can settle the claim without the carrier's consent, without breaching the cooperation clause. If Morris applied to title insurance, that's number one, and if they had come to Judge Burke and to this court with a $13.5 million stipulated judgment between the lien claimants and the insureds, that issue would be front and center before you. What do we do with that? We have a $13.5 million agreement between an insured being defended under a reservation of rights and a third-party plaintiff. Is that an effective Morris? We don't have to get there in this case because this isn't a Morris on its face. It's not between the insureds and a third-party plaintiff. The insured party plaintiffs didn't want to do a Morris. And again, An insured in that situation has options. One of the options is not to collude to create a friendly entity and then settle with yourself. That creates an entire whole series of problems. As the law is today, when an insured wants to do a Morris and the plaintiff doesn't, that's the end of the analysis in terms of a Morris. What CMLC argues here is there's another option available to insureds. Find somebody, a friend, yourself or a friend, to buy out the plaintiff, and then settle with yourself or your friend for a number that is multiples of what the plaintiff took.
But why can't it be harmonized with Morris, as long as you're not, you get away from the multiplier? If we're just talking about 13.5 and the original claimants have just, we want our money now, and we're actually going to take a discount, but we're going to assign it to, let's say it's someone other than in this case CMLC. It's just a wholly unrelated entity. It's just a relative of the mechanic lien holder. Why would that offend Morris or be inconsistent with the principles of Morris to just say, well, those people were paid off, they needed their money, they assigned their claim to their cousin. We've given the insurance company a chance to accept this settlement. They wouldn't do it without a reservation of rights. So under Morris, it's clearly a reasonable settlement with the lien holders, and so we've entered into that, and now the title company has to come in and show that was an unreasonable settlement.
Well, and I guess, and I understand Your Honor's point, and there's validity to it. That kind of settlement at least wouldn't offend the principles of Morris. It doesn't fit within the Morris confines, which is a settlement with a third-party plaintiff, but at least it doesn't have the problem that's created here. And see, you don't get to just go back to your $13.5 million settlement. If they had done what Your Honor suggests, stopped at the $13.5 million, done a $13.5 million quote-unquote Morris, and had a reasonableness hearing, frankly, that would have been deemed to be reasonable.
But isn't that the point of having a reasonableness hearing, though? Can't we come in and say, or would we have a basis for saying the reasonableness hearing went forward, but the reasonable number should have been 13.5?
Well, that's absolutely correct. If this was a Morris, the reasonable number would be 13.5. That's correct. But you can't have a Morris between two parties with common ownership.
Why 13.5 as opposed to 25?
Because 13.5 is what the claimants took. See, in the normal Morris situation, where you have an unliquidated personal injury claim.
Just go to A. Tumbling T. They had paid out $3.5 million,
right?
The dam owners, but yet it was reasonable to have a judgment of $14 million.
Because that's what the plaintiffs demanded to settle. They wanted $3.5 million cash and an assignment.
Aren't you looking at hindsight a little bit 2020 here? How do you know that under different circumstances the lien claimants would have settled for 13.5?
Because we know that's what they did settle for. There's no speculation. They took $13.5 million and walked away. Where's the ambiguity there?
What happened to all this whack-a-mole and all these things that were going on, this intense pressure that was going on to settle?
Exactly. That's why the $13.5 million settlement was probably a good deal. They took $30 million in lien claims, and they got the lien claimants to accept $13.5 million. That's what they took. That's all they got. They don't have any more interest in this litigation. And as I started to say, in the normal Morris situation, you don't really know what the underlying claim was worth. And that's the subject of the reasonableness hearing. Here, there's no speculation required. We know exactly what that claim was worth. $13.5 million. It's what they took. The lien claimants didn't take an assignment of rights. They're out of the picture. A single dollar over what the lien claimants took is unreasonable. But again, that all assumes this is a Morris. And if you say, this court can obviously enter whatever order it wants, but if the ruling here is that plaintiffs, that insureds who are being defended under a reservation of rights and have a plaintiff who's not interested in Morris, that there's a solution to that all they have to do is form a new entity and settle with themselves, that's a drastic extension of Morris. And the risk you run is exactly what happened here, is that when you have the same entity on both sides of the transaction, you have an incentive, a shared incentive, to stick it to the insurance company.
But that assumes that's the point of the reasonableness hearing, though. If that's unreasonable, then then they don't get more than the 13.5.
Well, that is correct, but it has to be a Morris. You only get to reasonableness and collusion if it's a Morris agreement. Heretofore, a Morris agreement has been between an insured and a third-party plaintiff. And Your Honor's asking, should it be extended to another situation where there's no third-party plaintiff involved in the agreement? That's not what Morris says.
But I guess I'm having a hard time understanding why Morris would necessarily preclude simply assigning it, setting aside whether it's going to be assigned back in a way that you think is collusive, but just assigned again just to an unrelated third party. That doesn't seem to me to necessarily offend Morris.
If it was assigned to I think the Supreme Court, I guess, could extend Morris that far into the same rationale. It has not. And this court can do it too, certainly. But this notion that you don't have to settle with a third-party plaintiff, what you're going to have then is people speculating in Morris agreements. You're basically saying we're going to allow third parties to buy out plaintiffs and then stipulate with the insured for an inflated number and then pursue the carrier.
But the inflated number is covered through a reasonableness.
Well,
here,
you hope so. It wasn't in this case. There are two interesting things about Judge Burke's ruling in this case.
Counsel, before you go, sorry to interrupt you. If we affirm Judge Burke's ruling, doesn't your client still have the ability to contest coverage?
Of course.
And that's ongoing right now?
Of course. But if you do a Morris agreement, and the court in Guerrero and this court in the Leflet decision just a couple years ago said clearly, this court said in Guerrero, again, this court quoted in Leflet, plaintiffs' counsel have every incentive to avoid creating agreements outside the permitted parameters of Morris. If counsel negotiates such agreements, the result will be that their clients can collect neither from the defendant nor the insurer. That's the remedy. The remedy is not to say we might win on coverage. Fidelity is facing a stipulated $35 million judgment because Morris was violated, because you don't have the insured and a third-party plaintiff doing a deal. You have the insured and itself doing a deal. And lastly, and I want to save a little time for rebuttal, the problem with this was not lost on Judge Burke. He recognized the problem. He said the fact that CMLC is owned by CP2 could easily lead one to the conclusion that the settlement was collusive as an agreement among the same parties. But it would be unfair to the insureds because it was Fidelity's intractability which forced the insureds to create CMLC. Think about that. What Judge Burke essentially said was, if the insured is between a rock and a hard place, the rock being a reservation of rights and the hard place being a plaintiff who doesn't want to do a Morris, collusion is okay. It's okay to collude if you're really in a bad state. That's like saying that a convenience store can't sue a customer for theft because the convenience store wouldn't give the customer food, so he had no choice but to steal. Where in Morris or in any other case does it say that if the insured has few options, they can enter into a collusive agreement? That's not just an erroneous factual finding. It's an inappropriate application of law. I'd like to save the rest of my time for rebuttal. Thank you.
Thank you.
Good morning. My name is Richard Lorenzen, and I represent Centerpoint Mechanics Lien Claims, LLC, that I'll refer to as CMLC, perhaps, during the hearing. Mr. Hendricks is not planning to speak today, so he's allocated up to the full 20 or 25 minutes to myself. Initially, we'd like to confirm what is and what is not at issue in this appeal. Judge Burke, after a 5-day trial, specifically found that settlements under 4 separate insurance policies were reasonable. Insurance companies had been given notice, there was no fraud or collusion, and therefore the insurance companies were bound by the fact and amount of the settlements consistent with Morris. 2 of those policies were issued by a company called Commonwealth Land Title Insurance Company. Commonwealth didn't appeal. So there's no issue in this case as to the reasonableness of those policies, whether Morris applies to those policies, so on and so on. At the end of the day, all that's left are the 2 Fidelity policies. One of them is a large construction lender policy of about $160 million. The second one is an owner's policy for the parking lot of $875,000. Now,
If I can interrupt, were there any mechanics liens against the parking?
Yes, there was testimony, I recall, from the expert for Fidelity, Mr. Lotardo, who confirmed that he saw that the scope of the legal descriptions of some of the liens included the parking lots.
I thought the acquisition of the parking lot occurred well after all the work had been accomplished. No, is that incorrect?
There was yes, technically, but
I mean, and this is a very minor point, and you wouldn't disagree that the wording of the policy regarding the parking lot is different than the lender's policy wording.
it's an owner's policy.
Well, the wording is specifically as to liens.
I'll defer to the language of the policy, but the issue, there was evidence introduced at trial that, and I should back up, Mortgages Limited and ML Manager contended that the deed of trust did apply to the parking lot. The trustee in the Tempe Land Company bankruptcy case disputed that. And so rather than fight the fight, at that time, the property was purchased for $875,000. So there was a lot of baggage, a lot of barnacles already on that piece of property at that time. And this issue of, it came up at the hearing. There was evidence that there were liens that touched the parking lot.
Sorry to interrupt. We would like to get to just the fundamental question of why should a Morris agreement apply in this situation where there doesn't seem to be a sharp thrust of personal liability hanging over the head of anyone?
The simple answer is why it applies is because Morris applies to all contracts of indemnity. And a title insurance policy is a contract of indemnity. When the title insurer takes a reservation of rights, the title insurer exposes the insured to the economic peril that was identified in Morris, and it exposes the insured to the same conflict of interests.
But what potential liability did the insured face?
In this case, if the liability aspect of it is the loss of the property itself, we've addressed this in the brief. The concept of liability.
But let's assume your client had $15 million and could have paid off those liens on their own. What seems to be argued is a problem, and we don't have enough money to go forward with this project without resolving this. But that seems different than what was actually insured. If what was insured was just the priority of mechanics liens, would they have been liable? Who would have had to pay if a court ultimately found that the mechanics liens had priority?
Well, what would have happened is you can come up with innumerable hypotheticals. I mean, there could be a party that had money and it could pay to solve the mechanic liens, but I think we need to focus on the nature of title insurance. What it insures is, in essence, the value of the insured's interest as it was purported to be. In contrast...
But isn't it at the time of the purchase, and wouldn't the loss ultimately be borne by the title company? I'm having a hard time making the connection to the personal liability that the insured would have under this scenario.
Well, let me try and address different points there that you raised. The insurance policy, and I will get to your question, but I wanted to finish the point, if I may, Your Honor. Where there's $38 million in liens asserted against a $30 million piece of property, the risk of loss under the title policy is $30 million. That's what the title company is exposed to. That's the economic peril that the insureds are exposed to. Now, in that precise example.
Sorry for question. The policy limit was 30 million?
No, but what I'm saying is that since the concept is that what the policy ensures is the difference between you have a first lien. If you have a first lien, you've got a $30 million piece of property. If the mechanic liens are on top, you have zero. So in that circumstance, and this goes to a point that Fidelity makes in its briefs, a couple of points that I've never really understood. They say that all of this has to do with a decline in the real estate market. But there's no evidence of any decline in the real estate market, and that's not correct, because if the property had been worth $38 million, then the exposure to Fidelity would be $38 million. If the property was worth $100 million, the exposure to Fidelity would be $38 million plus the attorney's fees.
But that's the point I'm not making very articulately. The liability goes to Fidelity. There's no, the point of Morris was to avoid this personal liability on the part of the insured.
In that particular case, that was a tort claimant seeking a money judgment. In Your Honor's example, I think what you're saying is the lien holders just wanted the property. They weren't seeking a money judgment. And so where's the personal liability? I take that to be your question.
Well, my question is just what liability would your clients ever have suffered if you go to trial and the mechanics lien holders prevail? Doesn't the insurance company cover all of that loss?
Well, we would have hoped for that, but this reservation of rights left the insureds exposed.
Okay, but that reservation of rights seems different to me. That's if they have the right to. I'm sorry. Go ahead.
But that's the paradigm, Your Honor. I mean, I think we're on the right page. It's the reservation of rights. In the normal circumstance.
Can I go way back? Because I think the threshold issue that Mr. Burke identifies is dispositive if he's correct. And because Morris is a narrow exception to the notion that the insured can't settle on their own, and because there's no case law that would apply Morris given parties that we have here before us, it seems to me you're asking for a fairly dramatic extension of the law in Morris. And if we can't get past that, then this is all interesting but kind of irrelevant.
Well, then I should definitely address that.
For me, you should.
Well, Your Honor, part of I think the difficulty stems from something that Mr. Burke is also doing here, which is lawyers use the term Morris agreement in a shorthand reference to refer typically to settlements that look like the one in Morris. It's not a defined term. It has
not. However, the case law does say it's a narrow exception. It's not one that this court has created. It's never been extended beyond the bounds of an insured and a third-party claimant. And this would dramatically open the ability of people to sort of factor in the area of Morris agreements.
Well, so I think that if I was to define Morris agreement, it would be a reasonable agreement entered into by an insured or indemnity who is under a reservation of rights. That was really the holding. The court said—
We're just going to buy and sell and assign these agreements whenever an insurance company, and we'll have structured factoring companies involved. It just seems to me we're getting far afield of the Supreme Court's narrow carving out of the ability of an insured who faces the sharp thrust of financial liability, and that this really is a huge expansion of the law.
Well, and to that point, I respectfully think that Morris does cover it, because what Morris is talking about is economic peril. The phrase, the sharp thrust of personal liability, is used, and it goes back, I think, to Damron. And so one of the things that we did is we looked at the status of Black's Law Dictionary when Damron was published, when Morris was published. And the scope of the definitions, even of the word liability, are broad enough. When Damron was published, it said it goes beyond a debt. It's broader than a debt. And I think a very critical point is that the concept of liability, even in a money judgment, is nothing other than a person being exposed to the potential loss of assets.
Well, but loss and liability are different.
That's correct. But the ultimate effect visited upon a person who is personally liable for something is the potential loss of her non-exempt assets up to the amount of the liability. All that's protected are assets. There's nothing beyond that. A title insurance policy protects a particular asset in the inventory of the insured. The loss of that asset is as economically devastating to the insured as the loss of any other assets. For example, imagine, and it's not far from the facts of this case, that you have an insured whose only asset is the one that's insured by the title insurance policy. If that asset is lost because of a defect that was insured against, the person has lost all of their assets. It's no different.
So the title company is responsible to pay for that under the contract. Right,
They should
right.
be.
Isn't
But-
that
but
is
the
that
prob-
the answer? I mean, that's the simple answer. I understand, but what's the problem with continuing to follow the contract as opposed to deviating into the Morris realm?
Because it's the same problem that came up in Morris. If the insurance company stepped up on its duty to indemnify, then we would go with the contract. But here, they're saying
What do you mean by stepped up? I mean, they were litigating the case.
they took a reservation of rights. So what?
Doesn't that happen often in insurance matters?
Well, it may, but that's the key to the Morris decision, Your Honor. I think that what happened is the insureds were being defended. When Fidelity took a reservation of rights, they're saying, you may have to go through this entire litigation, lose the entire $30 million, be subjected to an award of attorney's fees, and then we're not going to give you any coverage. To me, that's no different than the risk that the insured faced in Morris. The insurance company.
Understood. Both sides in litigation are going to have risks, right? They're always going to have risks. I guess the question we're struggling with, or the issue we're struggling with, is why take this unique title insurance area, which you have to admit, I mean, virtually no cases throughout the entire country over the past 30 years have really applied this type of a settlement. I mean, it seems a bit unusual at best.
Well, I don't know how frequently these things come up and whether that is one of the causes of the relatively small number of cases, but this is a contract of indemnity that protected these insureds from third-party claims. Fidelity was defending the third-party claims and took a reservation of rights, thereby exposing them to economic peril.
But why wouldn't your client have been well served by entering into the agreement but letting Fidelity maintain the reservation of rights? If you think the 13.5 was a good settlement, if you have coverage, great. If you don't have coverage, you don't have coverage. But why? So why is it such a bad thing to reserve rights on Fidelity's part if they think there's a legitimate question as to coverage under the policy?
As Morris held, the bad thing is that this reservation of rights exposes the insured to economic peril. The court looked then at cases from other jurisdictions and found that the majority of jurisdictions hold that when an insurance company takes a reservation of rights, the insured can reject the defense.
But what's the peril if you settle for $13.5 million with the mechanic lien holders? What's the peril that your clients then face? They now have a claim against the insurance company for that 13.5, and if there's not coverage, they don't have it. But what's their additional peril? If the 13.5 was a legitimate settlement, we know that's it, and either they were covered or they weren't.
Well, the settlement this was not a situation where the insureds wrote a check for $13.5 million out of a bank account. Fidelity could have done that, I think. The dynamic would have been different if Fidelity had come to the table. Maybe the lien holders would have demanded more. It didn't happen. But what had to occur, and what did occur in this case, is that the only way to get any money for the lien holders was to sell the property. And the only way that this was done, according to all of the evidence, required that all of these other amounts be paid.
But isn't that's a function of your client's financial condition at the time? Seems unrelated to what was contemplated at the time the insurance policy is issued.
I don't think that's correct, because if you look at Morris, the framework to analyze the reasonableness of the settlement specifically includes the risks of litigation. And in this case, when you're looking at the risks of litigation, there are $38 million of liens that are set to wipe out an entire $30 million. Now, when the property is sold, essentially all of that money belongs to the lien holders. They're the ones with the senior liens. But they're, as part of this multi-party, very complicated settlement in February of 2011, agreeing that their money can be used to pay these other amounts. And at the end of the day, the total of $22.5 million is less than the risks of litigation and the exposure that Fidelity faced under the policy. If I could use as an example, in the alternative, let's say that the insureds had said, fine, we can't go on with this. We'll stipulate with you lien holders that your liens are senior to ours. We'll stipulate to your judgment for attorney's fees as long as you give us a covenant not to execute. You go ahead and foreclose. Wipe us out. The insureds would now be suing for $30 million plus the attorney's fees. So by capping it at what they had to give up in order to achieve this settlement, it's more conservative and it's less exposure to the insurance company than if they've just said, fine, you win, wipe us out. And that's what Fidelity insured. They insured the value of our property as against mechanic liens. Here it's $38 million, $30 million piece of property. That's what was at stake.
But that dovetails with the second concern I have about whether this is a Morris agreement at all, set aside whether the parties are proper. But if it had confined itself to the $13.5 million, it would be a different story, but you can't assume additional liability and then call that a Morris agreement.
I don't think that liability was assumed. They made that argument, but they're talking about a liquidated damages provision, which doesn't factor into this equation.
Well, no, there was, to get to that, the figure that was in the agreement, wasn't there more than that? Weren't there proceeds set aside for various things? It seemed to me that the only potentially valid part of the money was the 13.5 that was actually paid, and that the agreement went on to assume, I mean, I know that's their word and I can't think of a better one at this point, liability in a much larger amount that is inconsistent with the notion that you're protecting yourself only from the plaintiff's claims against you, who would be the lien claimants here.
Well, again, Your Honor, the plaintiff's claims were $38 million.
Right.
And
but you're able to negotiate those.
I'm sorry. I didn't hear you.
That was their initial claim, but the amount they agreed to was dramatically less.
The amount that they were able to get after paying all of the other required amounts out of the proceeds from the sale was that number. But from the insured's standpoint, they actually lost all of these amounts. But
doesn't that extend Morris again? Because you're adding in things that were not actually agreed to with the plaintiff and the third party claimant. I mean, it just, to me, highlights how this, cramming this into a Morris mold is a really tough sell.
Well, I think that there's two things. Cramming in your words, the paradigm of title insurance into Morris, I think, is an easy sell.
Well, I'm not even talking about that.
The paradigm is exactly the same. Reservation of rights exposes the insured to economic peril, and the insured should be able to enter into a reasonable settlement. This particular case is extraordinarily complicated. You're not going to see the likes of it, I think, again. where there were all of these different people, and this entity, Radical Bunny, was saying, no, I mean, we will not agree to this deal unless all of these amounts are paid and the claims against Fidelity are preserved. If people are not willing to do that, then we're going to let it crater. Mechanic lien holders can foreclose. We'll lose the whole $30 million, and that'll be the claim. So I think that it's the question then under a tumbling is, and as Judge Brown pointed out, is not how much did the adverse party get. The question is whether there are facts in the record to support the amount of the settlement. And here there clearly are. All aspects from the standpoint of the insureds under the construction loan policy, all of the aspects of the settlement were interdependent. All of these amounts had to be paid. The mechanic lien holders had to agree that they could be paid out of, in essence, their proceeds. And that settlement, contrary to what Fidelity has argued, occurred in February 2011. It's not the November document that just assigns the claims to CMLC. Judge Burke specifically found that the settlement closed in February of 2011. Mr. Duvall testified that Fidelity acknowledged that's when the settlement occurred, and Fidelity's complaint further acknowledged that that's when the settlement occurred. And that settlement was between and among all of these interested parties who said Fidelity's not going to settle. We have no option other than to sell the insured property. And the insureds are saying, okay, we will give up $22.5 million out of money that we have a right to receive so that we can get a hold of these mechanic liens. It's all intrinsically related to extinguishing the threat of the mechanics liens. You can't separate that from the other amounts that were paid. And the evidence to that was testimony by Mr. Hendricks, testimony from Mr. Winkleman, testimony from Dan Reeb.
Yeah, I'm not questioning the business wisdom or judgment or any of that. I'm just, again, raising questions about extending Morris, not only because of the parties involved, but because of everything that was added into this that I think is way beyond what Morris has ever contemplated. That's my concern. The business wisdom, I get.
And as to that, Your Honor, I think, and we've already not continued to argue it, but respectfully,
I don't really need you to answer
I really don't believe it's an extension. I mean,
Are there any cases, though, where the ultimate liability is something other than what the third-party claimant was seeking? Are there any Morris cases that involve an amount other than what's ultimately paid to the third-party claimant?
sure. I mean, A Tumbling is a good example. They're paid $3.3 million and had a settlement for $14.75.
But that ultimately goes to the claimant, right? They took some money up front, and then they then had the claim against the insurance company.
That's true, and that's why I would think that when you have a circumstance, most people I don't think have money or the assets to put together something as complicated and sort of unusual as this. But that's why I think that when you're dealing with a situation where the insured is using its own assets to pay, then the settlement should be what it actually used, what it actually paid to accomplish the overall settlement. And that amount should be within the range of exposure.
And how does that get you above 13.5?
Because they had to pay all of those amounts.
But not to the mechanic lien claimants, though.
That's correct. But none of the money would have been available for the mechanic lien claimants unless everybody had agreed that it could be used for these other amounts. Take, for example, the $3 million of the litigation reserve. The unrefuted testimony was that money would have gone to CP1. It was entitled to the money in terms of priority, but it had to give it up in order to as part of this integrated transaction to get the mechanic liens. I think that unfortunately complicates the matter, but doesn't warrant reversing the ruling, because there are multiple insureds under the policy, and Fidelity insured each one of them for their losses. So it's not, again, a situation where the insured was able to say, I'll give you a check for $13.5 million. The only way that they could accomplish this entire thing was to give up all of these other amounts and sell the insured property. And that's what happened. So there are facts in the record to support the court's ruling. And Fidelity still has its coverage defenses. So, thank you, Your Honor.
Thank you.
Thank you, Your Honors. 4 quick points. I'm sure my client from Fidelity had a heart attack when Mr. Lorenzen suggested that title insurance insures value to property. It does no such thing. More than $100,000 was poured into this property, and it was only worth $30 million.
$100 million.
Excuse me, $100 million. Fidelity doesn't insure value. Fidelity insures title. That title is as insured. We don't insure the value of the property. This property was underwater by $70 million through nothing to do with Fidelity, and Fidelity in no way ensures that the property is going to retain its value. We ensure that the title is clean. Here, the cloud on title was $13.5 million in lien claims. We know that for a fact. That's all Fidelity insured. That's the extent of their exposure. If that's what the claimants took, that's all it was worth. One of your honors asked, is there a single case where a Morris was approved for more than the third-party plaintiff settled for? Of course not. There never would be, because that is the value of the insured claim. 2 other quick notes. Judge Downey, you said it more articulately than I did. Show me a case where Morris was extended like this, where a non-third-party plaintiff is a party to it. And what happens? What's the problem with allowing an insured to settle with itself? The problem is you put a $35 million price tag on a $13.5 million settlement. That's what happened here.
But I go back to the same question. Is there a problem if you just put a $13.5 million price tag on that?
Well, if you did it within the confines of Morris, no. But I'm going to quote this court in Lefflet. Because Morris agreements are fraught with risk of abuse, a settlement that mimics Morris in form but does not find support in the legal and economic realities that gave rise to that decision is both unenforceable and offensive to the policy's cooperation clause. If you try to do a Morris and try and stick the insurance company for $35 million in a non-Morris agreement, it's not no harm, no foul, we get to go back to 13.5. You lose. You have violated the policy's cooperation clause by entering into an agreement that Morris does not permit. And that's what happened here. And lastly, they had an answer here. They did sell the property. What if they had just sold the property for $30 million and paid off the lien claims? A bunch of people wouldn't have gotten their money out. There were more than $30 million of investment in that property. That's unfortunate, but that was the easy remedy here. Why not just pay off the lien claims and sue Fidelity for the $13.5 million? Why didn't they do that? That's essentially what they did. They sold the property and gave CMLC the money to pay off the lien claims. Why not do it in a more direct way and just settle with the lien claimants directly? One easy answer, because then you're suing Fidelity for $13.5 million, not $35 million. Judge Downey is right. The only reason it was done like this, and they've tried to cram this square peg into a round Morris hole, is in an attempt to inflate the number from 13.5 to 35. It's completely unnecessary, and it's done only to set up an insurance company between 2 parties who are going to share in the bounty if they win. Thank you.
Thank you both for your arguments. We will take this matter under advisement and issue a decision in due course.
see you guys. I owe you a signed agreement or something. It isn't that I have a problem with it, I just haven't been in the house. How long?
That was actually in your face, that's why I'm not worried about it. Right, because now, okay, that at least would be, that question would be
About to. Couple of weeks, are you gonna be here for that? Check in.
Justin, nice to meet you.
How's it going?
It's going. Kind of ending towards the end of the first year. So
Oh, okay.
things are starting to ease back a little bit.
So when are you coming on board?
August 4th.
Okay, wonderful.
Yeah.
So you taking time off, go travel with me?
Me and my wife are planning on going to Italy for 9 days
wonderful.
just before, which is a nice kind of break and refresh.
Fantastic.
Yeah.
Good.
Yeah, I'm pretty excited.
Excellent.
Yeah.
Oh, we're excited to have you.
Anything excited for you over the summer? Or?
Oh, I might try to get out to like San Diego or something.
Yeah.
But nothing, I don't have any major plans. I took some time off last year. So.
Very nice.
You guys, yeah, this is nice.